May we recall case number 23/2156 of 2024, State versus Lindoguhle Mkhwanazi and 4 others. We thank the court for the indulgence to adjourn the matter for a short period so as to arrange a further date. We are in agreement that the date of the 2nd of May seems to be convenient to all the parties. However, as officers of the court, we are alive to the fact that at all relevant times, you have to assist the court at best as one can. In the short adjournment that we had to arrange another date, the board counsel for the state had to understand the legal consequences of the ruling that the court has made. We respect that the court had to make a ruling and respect that that ruling has to stand to all the parties. Now, the difficulty then is unfolded in the following. The applicants in their replying process requested the court to allow evidence, which evidence the court provisionally allowed. And I will use this word provisionally because that is where the legal challenge then starts coming in. Now, in their replying affidavits, the applicants made reference in numerous of their paragraphs in their responses to this provisionally allowed evidence, which we all seem to agree is new evidence. Now, the state, respecting the ruling of the court, accepts that the court is of the view you can merely argue or make any reference to this newly admitted evidence in your arguments. If we accept that as the parties, it therefore means the state has not been given an opportunity to reply to this new evidence because it is provisionally allowed. The state is allowed only to argue on its admissibility or not. If the court at the stage when the evidence is argued accepts it, not provisionally, and said, I'm allowing this evidence. If the court then makes that ruling, the court is not favored with the state's response to that now admitted evidence, whereas the applicants have had that opportunity. They have indicated whatever they want to indicate in their replying affidavit on this provisionally allowed evidence. Now, that becomes a problem. Simply to put it, we argue, you make your ruling that whatever I provisionally allowed, I'm now accepting it as evidence. One party would have commented to that evidence, but the other did not. Now, if we are at that stage of the proceedings, I'm not too sure whether is the court now saying, let's first argue that upon me making a ruling that I'm allowing this evidence, will the other party who was not given an opportunity to comment on it be given opportunity or not? Alteram. Now, the difficulty that we're facing now is the court is saying, argue on the admissibility. I will make an example. In a criminal trial, the state will say against the accused, this is now hearsay evidence, which I want the court to provisionally allow. The court will provisionally allow, and everybody will run with the case as if that evidence is provisionally allowed. But prior to the court making any ruling, the parties have to address the court on whether what has been provisionally allowed is now admissible. That is at the closure of the state's case. So that when the accused testifies, if he chooses to testify, he knows what kind of evidence he's facing. He's not facing a provisionally allowed evidence. He's facing either evidence that has been admitted or evidence that has not been admitted. Now, we are sitting in that situation where, as the state, we are saying, we accept the court's ruling. We will come and argue on the admissibility or not of this evidence. If the court says, I'm not admitting the DPP's affidavit, whatever the applicants have said about that, now is pro non scripto. It becomes out of the record. But should the court allow it, then the court is only one-sided story, of which the alteram partem would not have been given to the state. Now, we're sitting with that difficulty, and as I said, as officers of the court, we have to raise these things as early as they can and not wait until the 25th to say, but here's a problem. Because when that is raised, it will seem as if the state is now delaying the processes and all of that. We are just raising it to say, let it placed on record. We accept the ruling that the court has made. However, come the 25th, when we have to argue, there are two legs that we have to argue. Firstly, the admissibility of this evidence, and what are the consequences if it is admitted, basically. So I wanted to place that on the record and hear what's the court's and my learned friends' view of this legal, because it is a legal technicality that we need to address as the court places.
Mr. Mdojo?
Yes, please, Your Worship, first and foremost, I will start with an analogy. If we go to the High Court, we place on record we are disputing the admissibility of particular pieces of evidence. We don't have an honors to show that it is admissible, but the honors is on the state. My learned colleagues for the state will confirm. Before a trial, within a trial can start, to determine and adjudicate on the admissibility of the evidence, the defense will have to stand up and state the basis upon which the admissibility is being challenged. Fast track to this matter. At the first appearance, for number 1 and number 5, Mr. Damini says, we understand we bear an honors to show the existence of the exceptional circumstances. Can the state please give us that grounds so that from the word go, when we show the exceptional circumstances, the existence, we also incorporate the accountability to the grounds that the state will have raised. The state stood up and said, no, the right time will come where we will tell you the grounds. So as a result, it's against that background that in the replying affidavit, we state how one had to rely on State versus Damini and other cases by the Constitutional Court. We had to give just a generic information that we thought would be able to tilt the scale in favor of the applicant. Up until the answering affidavit came. And then when the answering affidavit is presented by the state, then the grounds are provided. Then we filed the reply. And then it's a very technical aspect, Your Worship, because now there is a number of legal instruments that are guiding this court. The norms and standard by the Office of the Chief Justice, that the judicial officer is imbued with the responsibility to ensure that the matter is handled as expeditiously as possible. And then the case flow management principle enjoins this honorable court to demonstrate judicial leadership by making sure that the right to finality in respect of the party who would have instituted the proceedings, in this instance, the applicants, because they are dominis litis. So now it's a quick fix that has now turned out to be a long-term disaster for the state, because we would not have been in this situation if the state upfront gave us the reasons. More often than not, in our bail courts, as we appear, the prosecutor will stand up and say, out of the factors in 60.4, all of them or few of them we are relying on. Then we know what case to make. And then, Your Worship, the situation we are in is that there was, for us to be able to supplement and amend, upfront, in advance, we had to show all the interested parties that this is what we were going to do in court. Tell us if there is an objection. And then procedurally, it's a pure procedural issue. That aspect was not forthcoming on the part of the state to say, Your Worship, mind you, the record still shows that there was further affidavit that was filed by the state. Upon the state realizing that they had to supplement a few issues, even though the state calls it a further affidavit, but in law, the right term for it will be a supplementary affidavit to supplement issues which was not objected to. So which means the state is given an opportunity to supplement again, having been granted an opportunity to supplement, even though the state had not closed its case. So my humble submission, Your Worship, is that this issue, as the court has correctly stated, in our heads of argument, both parties have to set out clearly why a provisional order should be reversed or why it should be made permanent, and then any other issues incidental to that determination, and then the issue of the bail itself. So no prejudice will be suffered by any party. It's an issue that will be easily cured by the addresses. Your Worship, with bail application, I understand that the principles and rules are relaxed a bit. It would appear in this case, especially from the part of the state, there has been this accent, this insistence on the adherence and compliance with the procedure. So that is all, Your Worship.
Mr. Wolmarant.
Thank you, Your Worship. I'm not going to repeat what I said earlier. I've already said it. But just to remind the court that this is an application. This is not a trial. And my learned friend for the state continually refers to this as if it is a trial. It's not a trial. This is an application. The applicant brings his application, the state responds, and the applicant then has a right of reply. They do not have that right. So, Your Worship, whatever my learned friend has said has no merit in it. This is an application. This is not a trial. So everything I said earlier about it, and hearsay evidence, Your Worship, is admissible. The source does not have to be disclosed. But we know where the source is. This is an affidavit which was in possession of the state. They knew about it because they supplied the information for it. So to now come and say, well, we've been taken by surprise or anything like that, Your Worship, has absolutely no merit.
Your Worship, I'm going to provide two explanations in reply, a long one and a short one. I'll deal with the long one first. And that is to endorse what my learned friends have said. The affidavit that seems to unsettle my learned friends for the prosecution is an affidavit deposed to by their own boss. And the fact that it unsettles them is unsettling in itself. That's the long answer, Your Worship. The short answer is, Your Worship has already ruled, and that should be the end of it. Thank you, Your Worship.
Clearly, my colleagues misunderstood my point. Definitely misunderstood my point. And I'll repeat it again. For starters, I do not understand the submissions by Mr. Volmarans and Mr. Jorgensen. The fact that the state had that affidavit does not change the fact that it became evidence in these proceedings. That is the bottom line. We had it in possession, so what? We had it, fine. But the issue of the matter, it now has to see light in these proceedings. When it saw light in these proceedings, it came at a stage where only one party has been given an opportunity to comment on it, and the other not. The basic principle, whether it's a bail application or whatever application, hear both sides of so that you can make a proper. The difficulty that the court will have is, should that provisionally allowed evidence become admissible, you only have one side that had commented on that evidence, not the other. That is the bottom line. Thank you, Bishop. Just my apologies. Now, you will be requested by one party to attach a value to that evidence based on whatever they would have aligned in their evidence and their replying affidavit. Whereas the other party, you don't have the opportunity to listen to the other party and put value on whatever they're going to say as a court basis.
I'm thrilled by the activity that is coming from both sides, the prosecution and the defense, and it makes one's mind to be activated on the legalities and principles attached to the proceedings. I've issued a directive ruling earlier on saying that I am not allowing the evidence coming from Eswatini court. I will refer to it as a directive. But in order not to close the door on the face of the applicant in their endeavor to reply to what the state have said, I provisionally allowed the evidence or the affidavit by the DPP. I think, in my view, that was a good move in that I did not close the door at the face of the applicants. I now know what is contained in their affidavit. I now know what their argument is, so I will be able to make up my mind whether to allow or not to allow the affidavit. Please believe me in that. I will make my mind. It will be an informed decision. I stand by the ruling I've made earlier on this morning. I stand by the ruling I've made previously. I will make a ruling later on when the time is ripe. Gentlemen, please rise. Due to unavailability of one of your legal representative, we have agreed in chambers that we have to postpone the matter to a later date, later than the date we have indicated to you earlier on, the 25th of April. The date now for arguments by both parties is the 2nd of May. So this matter is now adjourned to the 2nd of May. This is for addresses and arguments by both parties. We'll see you then.
Before she then said, we need to now arrange dates as to when the applicants file their heads and when we reply. In between today and the 2nd of
Moving
May.
from the 2nd of May
Coming
backwards.
backwards, yes.
Yes.
We don't need to be at court for those dates, Your Worship.
Yes.
Your Worship, we have I'm looking at the calendar as it stands. Today being the
8th of May.
the
of
8th
April.
of May. We have about 2.5 weeks. 3.5 weeks. May I request that my colleagues perhaps file on or before the 22nd of April? It will give them 2 weeks, and then we respond by the 30th of April. It gives us 1 week.
30th of April.
Now the court has to read this before coming to court. May I then shift back, Your Worship, and say, the 18th, which is next week, the 19th, which is next week Friday, it gives them 2 weeks. 17. For yours. So Roman is saying the 17th will suit him, and then we can respond the week after the 26th, by the 26th on Friday. Oh, there's not.
We actually arranged the 17th for us to file.
The 22nd suits me, the 17th doesn't. Maybe it should be on or before the 22nd. If my colleagues' sets are available before then, it won't make any difference.
I'm raising this because there are 5 applicants that will be filing, and we are only 2 to respond to the 5. Hence, we request at least that if by the 19th they would have filed, which is the next week Friday, they have the whole of this week and the whole of next week, and then the week thereafter, which gives us 7 days, the 26th, we can file.
You're not comfortable with that, Mr. Mdojo?
19 and 26.
Bishop, I will have to align myself to be part of the solution, not part of the problem.
That is your request, Mr. Volmorans. You say by the 17th you'll be ready.
Mine will be ready by then.
Mr. Killing?
My principal will be ready by then, Your Worship.
So it is therefore agreed that the applicants will file their arguments on or before the 19th of April, which is next week Friday. The state will then have the opportunity to respond, and they will have to respond on or before the 26th of April. And then on the 2nd of May, the parties will gather in here for arguments. Will I be favored with the copies of your arguments? I did provide you in chambers with my email
I'm not sure
address.
what my colleagues do have.
We don't have your email address. My learned friend has it. So he must. We will, Your Worship, you will have our bids before the.
I will appreciate that.
We'll get your email address.
Okay, thank you very much. The court now adjourns.
Mhla ka-2 May lona usuke enzobuka ngalo nina enkantolo. Before mhla ka-2 May ke abameli bazoshintshana ngama-argument babone ukuthi omunye nomunye uthini, ebese-ke ngomhla ka-2 sima phambi kwenkantolo ke baqophisane phambi kwenkantolo. You understand?
Thank you. Court adjourns.